Hello, everyone. My name is Ethan, and today is February 19th, 2026, 3:51 p.m. Welcome to AMC Lawsuits and Justice, Project Popcorn, the Scheme channel. And today we're going to pivot from the two playlists that we're putting together, and I want to focus our attention on a shareholder, AMC shareholder and APE shareholder, by the name of Nelson Willis, and I feel like I let him down. And it's a huge miscarriage of justice, and his name has been tarnished as well as me with regards to helping him out. Um, So let's begin with his story. I'm going to start off with a federal lawsuit that I drafted for him. And in the federal lawsuit, there's um, what's it called? A statement of facts, and we'll go over it and we'll supplement it with the criminal matter. So I drafted this lawsuit for him, and it's a verified complaint. And what does that mean? Is that at the end of the document, he executes it before a notary. And as you can see, his name is Nelson Willis, and he went pro se. And we have a table of contents, and then we'll go straight to page 14 with regards to the statement of facts and what happened. So let's quickly go down to 14. There's a little background explaining that he's a shareholder, but the key thing I want to focus on today is why he brought this lawsuit. So let's begin. And here it is, statement of facts. So basically, Nelson Willis, he gave me his story and I put it together. He suffered with congestive heart failure since June of 2022 and has been in and out of hospitals several times in that last year. On March 7th, 2023, he was admitted to Presbyterian Hospital in Dallas to have a heart ablation surgery performed on March 8th, 2023. During that surgery, plaintiff Willis was infected by Staphylococcus in his chest. And then Nelson was then released on March 13th. And then the following day, he placed a call to 911 from his house, and he was transported via ambulance to another medical center and was kept overnight, specifically Texoma. And then Nelson, he did not get released from the hospital until March 15th at 4 p.m. And then he addresses his attention to March 14th. His sister was there, and they were looking to cast votes for the APEs. Now let's go back in time. Remember, APE was launched on August 22nd, 2022. And as you recall what happened with APE, then they made a deal with Antara, and then they were going to have a shareholder vote about conversion reverse split. And I think the date of vote was March 14th. So then Nelson realized that both he and his sister did not receive their proxy voting statements for the AMC shares. He was extremely disappointed. Now, AMC's corporate voting process uses proxy vote for the majority of brokers so that shareholders can vote online without having to show up in person for agenda items determined to be voted on for shareholder meetings. So a few weeks before the meeting, shareholders generally receive an email from their investment broker that holds the instructions for proxy voting for each account that holds the applicable security. On speaking with other shareholders, some received proxy statements for both AMC and APE for each account that they held their securities, which would be the correct process. However, some shareholders did not receive their proxy statements or received the incorrect amount. Nelson Willis and his sister were two of the many AMC stockholders that did not receive their AMC proxy voting statements. They only received their APE proxy voting statements for the shares they held with Fidelity and Interactive Brokers. With the incomplete number of proxy votes, Nelson he voted against the March 14th, 2023 proposals for a reverse split and merger. After casting his vote while lying down in the hospital bed, Nelson Willis decided to watch CNBC. While watching CNBC, he discovered that AMC vote was approved. Nelson then sent 4 emails. Now, mind you, this is to John Merriweather at AMC Investor Relations. He sent one on March 14th, then he waited 3 days, then sent another one on the 17th, then on the 21st, and then on the 24th. With these emails, Nelson expressed his frustration with not getting his AMC proxy statement and demanded an explanation. At no point did he receive a response email from John Merriweather or AMC Investor Relations. Now, I could attest to this. I've sent many emails to John Merriweather, and if it's a softball question, he responds. If it's a hardball question, completely ignores it. So then on March 25th, after emailing John Merriweather and Investor Relations multiple times, he had enough and his patience ran thin. So then he sent an angry email to Adam Aron asking how could he advertise the voting proposal of reverse split and merger was approved by shareholders when many shareholders such as himself never received the correct number of their proxy voting emails. Therefore, they were not able to vote all their shares. If shareholders were not sent the correct number of proxy votes and were unable to vote with the correct number of votes, then clearly the voting results were incomplete or possibly fraudulent. Despite Nelson's concerns, his emails to Adam Aron were ignored. No one at AMC would entertain his question regarding his missing proxy statements. Nelson then sent some angry emails, and then finally on April 3rd, Adam Aron replied. Instead of entertaining Wilson's inquiry and concern, Adam Aron says this: "I hope your parents are alive to see your hateful emails." Now, I've seen his emails. It's not the nicest thing, but he's a shareholder, right? And at the end of the day, Adam Aron doesn't respond, "I'm being harassed. I'm being, what's it called? Anything of harassment." He says, "I hope your parents are alive to see your hateful emails." Now, mind you, in light of what happened and the discovery documents exposing Adam Aron, this gentleman had every right to be angry. I'm beyond angry. I've also reached out to Adam Aron and cursed him out. Anyway, Nelson was not happy about that. He responded angrily and then began reaching out to the SEC chair, Gary Gensler, and Hester Pierce, and copied Adam Aron and John Merriweather in the emails. So mind you, he then reaches out to the SEC and then CCs Adam Aron and John Merriweather. What happens next? He gave the SEC notice about him missing his AMC proxy statements and about the March 14th, 2023 rigged AMC vote. Unbeknownst to Nelson Willis, Adam Aron then filed a criminal harassment charge against him with the Leawood, Kansas Police Department. So now listen to the timeline. On June 15th, 2023, at approximately 7 a.m., plaintiff Willis was served with Adam Aron's petition. So let's go over his petition. So this is what he got served with. This is the notice of hearing. He was given instructions that he has to appear at 3 p.m. on the 13th of July of 2023, and he could respond. So Adam Aron was trying to get a preliminary temporary restraining order, and this is what you can see right there. I don't want to get too depth, but it's an order setting a hearing on Adam Aron's application for a protective order, and the judge signed it on June 12th, 2023. All right. All right. So this is the petition. We'll go into that a little bit later. And this is Adam Aron's affidavit. He said, "My name is Adam Aron, or M. Aron. He's over the age of 18. He goes, I'm the chairman and CEO of AMC Entertainment. He said, since April 3rd, 2023, I've received harassing, threatening, and offensive emails to my AMC's work email address from an individual named Nelson." And then he says, "Many of these emails contain hateful speech directed at me, which qualify as ethnic slurs. Many of these emails were also sent to AMC's investor relations." On April 10th, 2023, then Nelson began including the SEC, he even acknowledges it, and Pierce as recipients of many of these emails. Despite receiving no response from me, Nelson was continued sending these harassing, threatening, and offensive emails to me and about me to others. And then on Monday, April 17th, 2023, he sent 10 harassing, threatening, and offensive emails to me, including others as recipients. Nelson then repeated emails to me about me and others have caused me to feel harassed, annoyed, alarmed, tormented, embarrassed, and offended. I asked the court for protection from Nelson in my application further, the affidavit, and then he signs it, something to that effect. So let's come back full circle on this. He starts off with since April 3rd, he mentions. Doesn't mention anything else about his initial emails to John Merriweather that I told you in March. He intentionally leaves that out. Nelson is a shareholder, and investor relations intentionally ignored him. And this was a hardball question. They don't want to deal with proxy. If Nelson asked them, "Yeah, what's the weather out in Kansas?" John Merriweather would have responded. But you ask him about the proxy, and his failure, the AMC's abject failure to produce it for him, they're not entertaining it. So imagine, he first starts off his allegation in reference to April 3rd, leaving out material facts of what happened prior. And I mentioned to you, Nelson sent emails. Once he was at the hospital, he inquired, "Where are my proxy?" And John Merriweather never responded to him. Then he went to Adam Aron. And then, mind you, Adam Aron also admits he started. Nelson is a red-pilled shareholder. He's aware of what's going on in the world. And then he sends the SEC, specifically Gary Gensler and Pierce, emails. Then Adam Aron has to shut him down. So mind you, he says he's harassing this and that. Now let's go further in depth. Where is it? Hold on. Back to the federal lawsuit. Hold on. So on May 19th, 2023, Adam Aron filed a petition with the court for a protective order seeking the following relief against Nelson. It was a temporary ex parte protective order prohibiting Nelson from communicating directly or indirectly with Adam Aron in a threatening, harassing, offensive manner. Then prohibiting Nelson from communicating in any manner with Adam Aron except throughout Adam Aron's counsel or person appointed by the court. And then prohibiting Nelson from engaging in conduct directed specifically toward Adam Aron that is reasonably likely to harass, annoy, abuse, torment, or embarrass him, including but not limited to communications about Adam Aron to others, including to other corporate mailing and email address of AMC and to the SEC. So that's the key. Adam Aron in the protective order, what does the SEC have to do with it? It's a government entity. He has a right to reach out and file his grievances with the SEC. So was his Adam Aron's intent really because he felt like he was being harassed, or is he trying to silence Nelson? Then Adam Aron requested that the temporary ex parte protective order be effective until a hearing can be held for entering a protective order, as opposed to a temporary. Now he's asking for the protective order. He's prohibiting Nelson from communicating directly or indirectly with Adam Aron in a threatening, harassing, or offensive manner. Basically, it's the same thing. And once again, we highlight a key point. Doesn't want him to communicate with the SEC. So now Adam Aron's petition, he alleges in allegation number 8 and 9 that Nelson, on April 3rd, 2023, using the email address nelsonwillis3@gmail.com, he began repeatedly sending harassing, threatening, and offensive emails to Adam Aron and about Adam Aron to others. Many of the emails contain hateful speech qualifying as ethnic slurs and about Adam Aron. Adam Aron alleges that Nelson conducted or his conduct constitutes stalking under Section 42072 of the Texas Penal Code. Now, Adam Aron's petition was assigned cause number Civ 23-00179, and a hearing on Adam Aron's application for a protective order was scheduled for July 13th, 2023 at 3 p.m. Now, on July 7th, 2023, Nelson filed his 60-page opposition. Now, mind you, for those who don't know, usually in court, a party files either a motion, order, show cause, and then the ball goes to the other party, and they have to either respond to it. It's called an opposition, and then the ball jumps back to the party who started the initiation, and they have a chance to submit a reply. So what Adam Aron did was file his petition, and now Nelson has an opportunity to file an opposition. And what he did is submitted a 60-page opposition, which included his 30-page affidavit and over 20 exhibits with the court, and served Adam Aron's attorney via email. Now, as we stated, a hearing was scheduled for July 13th. And when I was talking and helping Nelson, I said, adjourn it. We need more time. So Nelson filed an agreed motion because he reached out to the opposing counsel for a continuance. And so Adam Aron's attorney agreed to it. And he filed the continuance with the court, and his motion was granted, and the protective order hearing was rescheduled for July 21st, 2023. Now, for those who don't recall, why is July 21st, 2023 important? Because that's the day Judge Zern denied the settlement hearing, the first one, and the stock ripped. That same day, Nelson was scheduled for a hearing. So now let's go to the hearing. So on July 21st, the protective order hearing was scheduled for 3 p.m., and Nelson made his appearance in courtroom 217, for the scheduled protective order hearing before Judge Janelle Haverkamp. and the matter of the petitioner Adam Aron versus Nelson Willis. That afternoon, Judge Haverkamp took appearances and recognized that Adam Aron was not present in the courtroom. So Judge Haverkamp addressed Adam Aron's attorney, inquiring where her client was. Adam Aron's attorney responded that she was not aware that Adam Aron's location. However, she was prepared to proceed without him, and that she had some evidence in the form of an affidavit. Now, Judge Haverkamp was pissed, and she chastised Adam Aron's attorney for attempt to make a mockery of the protective order proceeding. She cited the Sixth Amendment, stating that Willis had a constitutional right to cross-examine Adam Aron. At that point, Judge Haverkamp rescheduled the protective order hearing, setting it for August 7th, 2023. Now, it's not alleged in here, but this is what happened. Now, mind you, once the hearing was over, Nelson reached out to me, and I said to him, "Do you want to put him in checkmate?" And he goes, "How would we do it?" Because it was a win-win if we moved either direction. If the hearing went through, Nelson had an opportunity to cross-examine cross-examine Adam Aron. Or did he want this and put Adam Aron in checkmate? And how would we do that? I said, here's the deal. Let's file or make an application for 2 subpoenas. And there's 2 types of subpoenas. One is to force someone to come and testify, or to subpoena ducis tissum, which is to get documents. So I helped them draft these subpoenas, and on July 28th, 2023, Nelson made an application before the court for a subpoena, and a subpoena ducis tissum ordering, now listen to who it is, John Merriweather. Now, mind you, why did we subpoena John Merriweather? Because he controlled the email account for investor relations. So one was to ask John Merriweather to appear on August 7th, 2023 at 2 p.m., and the second was to produce and permit inspection and copying books, papers, documents, and other tangible things. So Nelson was going for the jugular. He's now going to have an opportunity to cross-examine John Merriweather and to ask for documents. So then on July 28th, Nelson's application was granted, and his subpoenas were issued by the Johnson County District Court in Olathe, Kansas, instructing the sheriff of Johnson County, Kansas, to effectuate service on John Merriweather with Nelson's subpoenas. Now, what happens? Now, listen to the timeline. So that was July 28th. Now, on July 31st, sometime between 8:30 and 9:30 a.m., the sheriff served John Merriweather with Nelson Willis subpoenas. And what happens after that? So mind you, now they got served. And what happens? Magically, subsequently, on July 31st, 2023, at approximately 5:58 p.m., Nelson Willis was served with Adam Aron's motion, a notice of non-suit without prejudice, pursuant to Rule 162 of the Texas Rules of Civil Procedure. What that means is Adam Aron non-suited all claims asserted against Nelson Willis. That means he dismissed it, but he could always come back. But he dismissed it. If Adam was so threatened, so afraid, the emails bothered him. Now, mind you, the first thing he writes to him is, "I hope your parents are alive to see these hateful emails." Now, mind you, Nelson's I think his mother or his father, a couple of years ago, prior to that email, passed away, so that pissed him off. I forgot if it was both or just one of them. But imagine, so this is the people were obfuscating, like this guy, Noisy Korax. I could have testified to this guy. I helped him out. You have to understand the timeline. On the 28th of July, 2023, Nelson makes an application for the 2 subpoenas. One is to force John Merriweather to come testify, and second, to produce documents. And once they get served in the early morning, because the timeline we forgot, it was between 8:30 and 9:30, that evening, of all days, Adam Aron's attorney non-suits, meaning he dismisses it without prejudice. So let's continue. On May 19th, Adam Aron abused the judicial process when he filed a baseless petition for a protective order against Nelson Willis, a valid AMC stockholder, in order to silence Nelson Willis from reporting fraud, disseminating and exposing his role in the pernicious financial engineering scheme that was perpetrated against AMC shareholders, and his abject failure to rectify the proxy voting issues to the SEC. Plaintiff Nelson Willis was maliciously prosecuted for 46 days. Through Adam Aron's protective order petition, he was able to procure a temporary ex parte protective order against Nelson Willis that lasted for 46 days. On July 31st, the spirit of justice prevailed for another Texan. Now we show information. It's a tweet to substantiate that this is what Adam Aron says. Back on June 7th, 2021, at 11:24 a.m., Adam Aron made the following representation to us AMC shareholders via Twitter account. He says this: the financial press has banner headlines about how innovative AMC and I are reaching out to our individual investors. Odd that they praise something so obvious. CEOs and professional management team should listen to shareholders. You own our company. We listen to you. So imagine, Adam only wants to listen when it's good stuff. When it's negative, this is what he does. He retaliated. Now, mind you, he only he made an application that was being harassed once Nelson was reaching out to the SEC, both Gary Gensler and Pierce. So Adam Aron has hosted over a dozen meet and greets events at both AMC and Odeon movie theaters across the United States and across the world. At these events, Adam Aron consistently speaks the narrative publicly that he's the CEO that works for the shareholders, and here's the shareholder concern. Now, Adam Aron also pushes his narrative during public AMC earnings call, during which broadcasted interviews and on his own personal Twitter account. However, when shareholders report serious issues, such as not having correct voting rights or loss of stock value, Adam Aron ignores their concerns, or in this case, lashes out against shareholders. Anyway, with that said, we're going to stop right here. Next video, I'm going to show you evidence. But imagine, this is the storyline. This gentleman, Nelson, was at the hospital, didn't get his proxy, is pissed off. Investor Relations doesn't respond to his emails, then reaches out to Adam Aron. Adam Aron's first response doesn't say he's being harassed or this. He says, I hope your parents are alive to see these hateful emails. And then he pivots that once he forwards these emails, starts emailing the SEC and CCing Adam Aron in Investor Relations, Adam Aron then goes and files a protective order. And then what does he do? He also asks requests that Nelson does not communicate with the SEC, which is his constitutional right. The SEC is a color law, and the Constitution protects us against the government. So him reaching out to the SEC is his constitutional right. He can even curse them out and do whatever he wants. That's protected unless he threatens them. Then it could be curtailed. Anyway, we'll continue. Next video, we'll go further in depth, and we'll show you documents, and we'll go over the transcript. It's a key thing of what happened on July 21st, and you can see how the judge warned Adam Aron's attention and said, listen, how come your client's not here? I'll leave you with this. I always wondered, if we didn't go for the jugular and submit these subpoenas, what would have happened if actually Nelson had Adam Aron the stand? Anyway, leave comments. Tell me what you think if we went with the other direction and Nelson had his day to cross-examine Adam Aron. Do you think he would have continued, or he would have waited the last minute and been non-suited because he didn't want to take the stand? Anyway, have a good day. Have a good night or good afternoon. Ciao.